So the next few lectures are related to interrogation and confessions. In this first section, I will cover interrogation as we know and use it today by starting with a brief history of where interrogation came from, and then I will go into depth of the most used interrogation technique used by law enforcement today in the United States, which is called the Reed technique. Although torture existed before the 16th and 17th centuries, the Malleus Maleficarum was written in the late 15th century and was used to identify and prosecute witches who were believed to be the reason for the Black Plague that killed 25 million people beginning in the 14th century. Anyone at the time that did not fit the status quo of Christianity was likely deemed to be a witch. This included, for the most part, groups such as old women, midwives, Jewish people, poets, and gypsies who were targeted the most and deemed likely to be witches. Now, the book was divided into 3 sections. The first was to answer skeptics who thought that witchcraft was just a superstition, and then attempted to prove that the practice of witchcraft was real, that those practicing witchcraft really did make agreements with the devil and cause harm to others. Beyond that, the section asserts that not to believe in witchcraft was real in itself, was also a form of being a witch. So if you didn't believe that witchcraft was real and that it was dangerous, you were essentially just as bad as a witch. And then this may also subject you to being accused of being a witch, which you don't want, as you'll learn through the prosecution of witches. The second section sought to prove that real harm was caused by the Maleficarum. The third section was a manual for the procedures to investigate, arrest, and punish witches. So how do we deal with witches? Well, the Malleus Maleficarum had many ways to deal with witches. For the most part, though, that was torture, because you wanted the witch to confess that she was a witch and give you information about other witches. And some prosecution of witches included the inability to drown or burn a witch who still had any witchcraft concealed or who were under the protection of other witches. So if you couldn't find any marks of the devil on the woman, but you believed they were there, you could believe that the witch was hiding them from your vision. And so there were tests that were made to determine if a woman was in fact a witch or not, regardless of whether she told you or allowed you to see the symbols that were tattooed on her. So one way that they tested to see if a woman was a witch or not was if she could drown or die from being burned. If she drowned, if you put the woman in the river and she drowned, then she wasn't a witch. She was innocent, but of course she was not alive to enjoy that exoneration. So unfortunately, many people died. The estimates of the death toll as a result of the Inquisition range from 600,000 to as high as 9 million over the course of 250 years. There are reports that some days the smoke from the burning bodies was so thick you could not see the sun. But the Malleus Maleficarum came to the United States following the Inquisition in Europe, and this is where at least 19 men and women were killed in Salem for being witches. When accused of being a witch, suspects were often tortured until they confessed. So either they died from the torture or they died because they confessed they were a witch. Either way, you were likely going to die. But it wasn't until the 19th century that courts began to reject confessions as a result of torture, but physical coercion or lighter forms of torture were admissible to extract confessions, so they could possibly, the TV example is pistol whipping a suspect into confession, but as long as it wasn't torture, then it was admissible. In the 1930s, however, a little bit later, we found that physical coercion was no longer acceptable, and confessions are now considered on a case-by-case basis. As to what constitutes coercion must be determined by the trial judge. More on this will be discussed in the confessions lecture, but often trial judges do not dismiss confessions, likely because they do not particularly believe people will falsely confess as often as they unfortunately do. And also because judges think jurors are able to tell the difference between true and false confessions. Spoiler alert, they can't. So, in the history of interrogation, we went from physical torture and murder of up to 9 million men and women, and then we calmed down a little bit here in the United States and used some forms of physical coercion, and now it's not legal for interrogators to touch you during interrogation or use threats, explicit threats. So now that physical coercion and torture are inadmissible, many believe psychological manipulation is the best way to get someone to confess to a crime. The most widespread technique in the United States is, as I said earlier, the Reed technique. It is important to know that the Reed technique employs 3 stages, but the psychological manipulation begins before the interrogator enters the room, usually. The physical layout of an interrogation room is designed to maximize a suspect's discomfort and sense of powerlessness from the moment they step inside the room. The classic interrogation manual, Criminal Interrogation and Confessions, recommends a small, soundproof room with only 3 chairs, 2 for detectives, 1 for the suspect, and a desk with nothing on the walls. So this creates a sense of exposure, unfamiliarity, and isolation, and heightens the suspect's get me out of here sensation throughout the interrogation, but also kind of giving them the sense that they can't just leave because there's an obstacle between them and the door. Additionally, I've seen suspects that were left in a room for extended periods of time to kind of let them sweat what is happening. So when I worked at the public defender's office, many of my clients were recorded for over an hour before an interrogator entered the room. Some exonerees have reported being left in closets that had boxes with their name written on them, presumably to make the suspect think that the police have tons of evidence against them. So there are techniques that are employed before these 3 stages, but once the interrogators enter the room, the first stage is just to gather evidence. So this is gathering evidence from the suspect, which usually just comes in the form of just open-ended questions. They use this time to build rapport to get the suspect to feel more at ease. And this also continues on to the non-accusatorial interview to assess guilt. So they won't tell the suspect that they're interrogating them, as they are trying to keep the suspect from putting his or her guard up. And during this time, they begin trying to determine whether the suspect is lying or not based on behavioral cues, which you have learned in lie detection section that people are just terrible at this. It's not a useful form of lie detection, but they use their behavioral baseline demeanor as a way to assess their reactions as the questioning becomes more serious. It's important to note that Reed and Associates know about the research on deception detection, but they claim that it's flawed, and they cite the use of college students, the lack of training by researcher, no baseline behavioral measure, and claim the research is done in a vacuum, which some of those points are not unwarranted, but overwhelmingly the scientific evidence, as you know, probably at this point, that it's just human deception detection is not good. And finally, the interrogator ups the ante and becomes increasingly accusatorial and incites anxiety. At this point, they start accusing the suspect of committing the crime and kind of start stressing them out. So those are the 3 stages of the read technique, and then we'll get into the specific 9-step processes.